I have remaining questions on fundamental rights, DPSP, and on Supreme Court. Because I said I asked you all to revise Supreme. Let's continue with that. Let's go to Article 22. Before that, just wanted to quickly ask what are you finding more useful? Are you finding doing questions more useful, revision more useful? What should I focus more of the time on? Okay, yeah, I'll do both then. So we finished Article 21, right to education. So let's continue with Article 22. Article 22 talks about right against arrest and specifically about preventive detention. Fine. So on that, Article 22, like there are two parts to it. First part is about rights for normal arrest, which is known as punitive detention. So in punitive detention, you have right to consult a lawyer. You have a right to be informed of grounds of arrest and to be produced before magistrate within 24 hours. And if you don't have, if the magistrate says there's no proof to hold you, then you will be released within that 24 hours. Second part is the important part from a questions point of view, which is preventive detention. So preventive detention, first, is that protections under preventive detention are available for both citizens as well as foreigners. Okay. Secondly, that there are grounds and procedures for preventive detention. First is the scope of the preventive detention law. One very important fact is that both parliament as well as state legislatures can make laws on preventive detention, and which is why you have Maharashtra specific acts, you have Tamil Nadu specific acts. Okay, preventive detention, both parliament as well as state legislature can make laws. What does the parliament cover? Parliament covers defense, foreign affairs, and security of India. State covers security of state, public order, and supplies and essential services. Then there's always parliament can prescribe a board which will supervise preventive detention and who all have and the conditions of preventive detention. And yeah, like I think from a questions point of view, that's all. Then there is Article 23. Article 23 is prohibition of human trafficking, and forced labor. So forced labor is also known as Begar, BEGER. That's an important term. Then forced labor can also mean if someone is forced to work below minimum wage. That is also forced labor because it is economically forced labor. So that's an important fact that can be asked in questions. However, one of the exceptions under Article 23 is something known as conscription. Conscription is when the government prescribes compulsory service. The term for that is conscription. So if the government says that all individuals above age of 18 have to serve for 2 years in armed forces, okay, supposing government says similar to what countries like Singapore and South Korea have, then that is allowed. I'll send the spelling of conscription. There's a doubt about what if the facts are not there in Lakshmikant book, what to do. Okay. So what you need to know is that very rarely UPSC asks questions directly from Lakshmikant. Okay. Lakshmikant is an important book. Without reading Lakshmikant, you will not be able to understand polity. But don't think that if UPSC asks 20 questions in polity, 20 questions will come from Lakshmikant. Lakshmikant lo at max 4 to 5 questions will come. And those 4 to 5 questions you have to get right because book nunchi vache. Everyone who is qualifying will get those right. The remaining questions will be slightly more advanced than Lakshmikant, more tricky than Lakshmikant wording. Like there'll be the kinds of questions which are making you do in class. Okay. Directly from Lakshmikant, UPSC does not ask. There'll be questions similar to what I am giving you. So the resources then is to do as many questions as possible. First and most important resource is to do all previous year questions. If you do all previous year questions polity ninchi, then you will have an idea. What is UPSC asking? How is it asking questions? In fact, in class, I'll keep telling you what statements, what sections have been asked as previous year questions. So focus on that and you'll be able to keep building. The key is to do as many questions as possible, which is why in class also we'll do questions. Next, so that is Article 23. Article 24 is about child labor. So child labor currently, it is that individuals up to age of 14 should not be employed in anything. Why? Because this is consistent with RT. Second is that between 14 to 18 years, children are allowed to work. except in three hazardous industries. Okay, I think the hazardous industries are like mining and all. Okay, but except the three hazardous this industries, rest everything they are able to work. And below age of 14, individuals are allowed, like children, are allowed to help parents in family businesses. So if you have like family buddy shop or something, in that children can help. That is not considered as child labor. That's Article 24. Article 25. Article 25 is about right to freedom of religion. So 25 in specific is about the individual's right to freedom of religion, which is freedom of conscience, profession, practice, and propagation. Four freedoms of individual religion. Okay. One important fact which has been asked in prelims before is that governments are allowed to regulate any economic, financial, political, or secular activity related to religion. Government is allowed to regulate economic, financial, political, or secular activity related to religion. So, where is government not allowed to regulate? It is not allowed to regulate the religious practice itself. Religious practice, either personal or organized, religious practice government cannot regulate. This is part of something known as essentiality doctrine. The doctrine of essentiality deals with which religious practices can be considered as an integral and important part of the religion itself. Essentiality doctrine. So this was in the news because of the Sabarimala judgment. Sabarimala judgment law, Supreme Court said that the Ayyappa devotees, regulating it will not be part of essentiality doctrine. Therefore, women should be allowed into Sabarimala temple. So, doctrine of essentiality case, if I remember correctly, is Shirur Mutt case. In Shirur Mutt case, for the first time, Supreme Court established essentiality doctrine. Fine. Second is that personal religious practices are subject to certain conditions as per the constitution. Case I think is Shirur Mutt case. I'm not entirely sure. Just look it up once. I'm telling this from memory. Shirur Mutt case, I think, is where the first time essentiality doctrine was established. Doctrine of essentiality in religion. Second, religious practices are subject to a few restrictions specified in the constitution. What are these restrictions? These are public health, morality, public order, and other fundamental rights. So religion is subject to other fundamental rights, public order, health, morality. What does subject to other fundamental rights means? It means that you cannot say that women should commit sati because it is my part of my religion. Why? Because it violates Article 14, which is right to equality. Okay? You cannot say that Devadasi system needs to continue because it is part of my religion. Why? Because it violates right to equality, violates Article 23 also. Okay? So religion is subject to the other fundamental rights. Fundamental rights are more important than religion. This is part of our constitution. Okay? Especially for individual rights. But this distinction, and very important fact, this distinction is not there for Article 26. What is Article 26? Article 26 is freedom to manage religious affairs. Manage religious affairs is mostly related to institutions. So if I have a religion, if I'm Jain or if I'm Sikh, I can establish a Sikh college. I can establish a Jain college. I can establish a Jain institution, a Jain temple, a Sikh Gurudwara. And I have the freedom to manage the Gurudwara as per my own religious beliefs. That Gurudwara can acquire property, it can regulate its own affairs. Government cannot interfere in the administration of this institution. Freedom of freedom to manage religious affairs. Now, what are the restrictions on freedom to manage religious affairs? It is public order, morality, and health. Here, fundamental rights, that restriction is not there. Okay. Similar to how we had right to equality, means that women cannot be treated subservient as per Article 25. Similar to how we have Devadasi system is not allowed as per Article 23. Meaning, in personal religion, you cannot establish these practices. However, Article 26 is not, this statement is important. Statement is Article 26 is not subject to other fundamental rights. Article 26 has only 3 restrictions. Article 25 has those 3 restrictions plus all other fundamental rights. Okay. This difference between Article 25 and Article 26. Fact-wise, is it clear? Article 25, the restrictions are public health, morality, and public health, morality, and this public order. Public health, morality, and public order. 25 includes other fundamental rights, 26 does not. Okay. And under article, relating to Article 26, there are also 3 conditions established by Supreme Court for a religious denomination to be considered as a separate section of that religion, which is that it should have individuals who believe in the doctrine, common organization needs to exist, and it should have a distinctive name. Under this, what has the Supreme Court said? Supreme Court has said Ramakrishna Mission, Anand Marg are part of our religious denomination. Aurobindo Society is not. Updated current affairs is that Ayyappa, devotees of Ayyappa are not a religious denomination. This was also part of the Sabarimala judgment. As a part of Sabarimala judgment, Supreme Court said that Ayyappa devotees are not part of a separate religious denomination. Next is Article 27. Article 27 says that any taxes should not be used for promotion of one religion. Okay. What is the implication of this? Implication of this is that Ayyappa devotees cannot be considered as a separate part of religion. Meaning that, supposing Ayyappa devotees say that not allowing women into Sabarimala temple is part of our religion. Supreme Court is saying Ayyappa devotees do not constitute a separate religion itself. They do not constitute an organized religion. Organized religion meaning what? Doctrine needs to be, belief, set of belief system needs to be there, organization needs to be there, distinctive name needs to be there. Supreme Court is saying that Ayyappa devotees are not a separate part of Hinduism. Ayyappa devotees are Hindus only. And in Hinduism, what do we have? In Hinduism, women are allowed into temples. Therefore, Ayyappa cannot have a separate saying that women are not allowed into temples because they are not a separate religion. Ayyappa devotees are part of Hinduism itself. That is the explanation. And this is part of the Sabarimala judgment given by the Supreme Court. Article 27 is easy. It says that any taxes will not be used to promote one single religion. But fees can be collected for providing of service. Next is Article 28. Article 28 talks about freedom from attending religious instruction. So in this, 4 types of institutions are mentioned. Institutions which are wholly maintained by the state, meaning you have Kendriya Vidyalayas, Jawahar Vidyalayas, government schools that are wholly maintained by the state. Then you have institutions administered by the state but established under endowment. If the endowment is religious, religious instruction is allowed. In the first case, if it is Kendriya Vidyalaya, Jawahar Vidyalaya and all that, religious instruction is not allowed at all. Okay. Then you have the next 2 parts. Next 2 are institutions recognized by state. Like supposing recognized by CBSE, recognized by ICSE, or you have institutions receiving aid from the state. The last 2, religious instruction is voluntary. Meaning, if I want to attend religious instruction, I can attend. If I don't want to attend, I cannot. Next, Article 29 and 30 deal with educational and cultural rights. 29 deals with protection of language, script or culture. So any denomination, including the majority, can choose to protect its own language or script. Article 30 deals specifically with minorities. Article 29 is any section, meaning it includes the majority. Article 30 deals specifically with the minorities. For minorities, what does it say? That they can establish their own educational institutions. Okay, you can establish your own educational institutions and administer them as per your own preference. And this is only applicable for minority, both religious and linguistic minorities. Within this, there are three types. There are three types of minority institutions as well. First is institutions that seek aid and recognition from state. Second, institutions that only seek recognition. And third is one that seeks neither recognition nor aid. If you seek either aid or recognition, meaning of the first two types of minority institution, then you have to comply with syllabus, with discipline, sanitation, employment, all of these conditions they need to follow. So supposing you are seeking recognition from the state, you cannot have your own syllabus. You need to follow the state syllabus. Supposing state government says that children should only have a school day of 8 hours, then minority institution also needs to follow it if it falls under the first two types. Third type, which is minority institution which does not seek recognition, does not seek aid from the state, that they can prescribe their own syllabus, their own curriculum. Article 32 is right to constitutional remedies. Under this, you have the writs. So for writs, let's look at it specifically. Under writ jurisdiction, Supreme Court has original powers. Original powers meaning individual can directly approach Supreme Court for violation of fundamental rights. If fundamental rights are violated, you can directly approach the Supreme Court. This is known as original jurisdiction. Supreme Court also has wide jurisdiction. Okay, wide jurisdiction meaning its power includes issuing of writs. Okay, meaning that supposing there is you go to a civil court or you go to a criminal court, that criminal court will only issue orders saying that this person has won the case, this person has lost the case, or you government officials need to implement this order. Supreme Court also has wide jurisdiction. Wide jurisdiction means that Supreme Court can also implement writs. Writ jurisdiction comes under the wide definition of Supreme Court powers. However, Supreme Court power of issuing writ is not exclusive. Why is it not exclusive? Because under Article 226, even high courts have the power to issue writ. Okay, so there are some important differences between High Court and Supreme Court writ jurisdiction, which is that High Court jurisdiction is limited to the state. Supreme Court can issue writs for all of India. Next, this Supreme Court can only issue writs for violation of fundamental rights. However, High Court can issue writs for both fundamental rights as well as legal rights. So High Court has wider powers under writs than the Supreme Court. Next is that the writ jurisdiction of High Court is discretionary. Discretionary meaning it can choose, the High Court can choose whether to implement whether to use its jurisdiction or no. But for Supreme Court, it is compulsory. If individual comes and says my fundamental rights have been violated, Supreme Court cannot turn that person away. So these are differences. Then quickly I'll run through the 5 types of writs. Habeas corpus meaning produce the body. It is used against illegal detention. Habeas corpus is the only writ jurisdiction which can be used against private individuals as well. If a private individual also has illegally detained someone, I can issue a habeas corpus. Mandamus means to command. Supreme Court will command a government official to fulfill his duty or his constitutionally obligated duty. Then is prohibition. Under mandamus, there's an important restriction, which is contractual obligation cannot be implemented under mandamus. Contractual obligation cannot be implemented against mandamus. And mandamus is also not applicable for Chief Justice of High Court, President of India, and state governors. Next, prohibition. Prohibition means to forbid. Prohibition is limited only to judicial and quasi-judicial authorities. Basically, Supreme Court will tell them that you have no authority to pass this judgment. That is prohibition, writ of prohibition. Next is writ of certiorari. Certiorari means that uh, it will transfer the case. Supreme Court will transfer the case from a lower court to itself. And basically, what a Supreme Court will say is that you do not have the authority. We have the authority to deal with this case. Therefore, we are transferring the case to ourselves. Difference between certiorari and prohibition. Prohibition is preventive in nature. Certiorari is both preventive as well as curative in nature. Last is quo warranto. Quo warranto means by what authority? It is used to check whether a person chosen into public office has the right to occupy that public office or no. Like supposing there is a government has made an appointment of someone as CVC. Suppose using quo warranto, you can ask, is that person qualified to become CVC or no? And quo warranto is the only writ which anyone can apply. You don't have to be an aggrieved party to apply for quo warranto. Difference between certiorari and prohibition is that prohibition means మీరు ఆ కేస్ హ్యాండిల్ చేయలేరు, క్యాన్సిల్ చేసేయండి, మీరు ఈ కేసులో జడ్జ్మెంట్ ఇవ్వకూడదు. సర్టియరీ అంటే మీరు ఈ కేసులో జడ్జ్మెంట్ ఇవ్వకూడదు, కానీ మేము యాజ్ సుప్రీం కోర్ట్ దీంట్లో జడ్జ్మెంట్ ఇవ్వగలము. అయితే ఈ కేస్ ని మేము ట్రాన్స్ఫర్ చేస్తున్నాము ఈ లోవర్ కోర్ట్ నుంచి సుప్రీం కోర్ట్ దాకా. దట్ ఈస్ సర్టియరీ. ఓకే. Then there are laws relating to martial law and relating to laws of indemnity, and that only Parliament under Article 35 it is that only Parliament has the jurisdiction with respect to effecting certain fundamental rights, which are 16, 32, 33, 34, 17, 23. Okay. So now instead of like delving into those details, which I think you would have all done already, let's look at some questions. Give me a second. I'll try and find. Okay, let's start with an easy question. I've posted the question. Fast. Let's do this quickly. Okay. Yeah. 90% of you have gotten it right. Answer is C. C for Chennai. Any doubts in this? Do you want me to explain something? I think it's straightforward, right? That basically, this is directly related to what we said. Like I led with this in the explanation also. I said judicial review is possible due to Article 13. What is Article 13? Article 13 defines what is a law. Definition of what comes under law. And anything that comes under law, Supreme Court has the right to review. But good, lots of you have gotten it right so far. Okay. So answer is D. D for Delhi. So under this, what is right to be forgotten? Right to be forgotten is basically, if there is some information about me available in online, then I have a right for that information to be forgotten. Like supposing there were allegations placed against one individual and later that person is found to be innocent. That person has the right for all the articles relating to his like allegations to be taken down. Why? Because it is affecting his reputation. It is affecting the way he lives his life, right? So that is the right to be forgotten. Or even otherwise, like supposing I am an individual who just does not want my articles relating to me to be present online. Okay. Then even I have that right to be forgotten. So under right to be forgotten, what you can do is individuals can send notices to Google, Facebook, all these companies and say that I don't want any information related to this to be out in the public because it is my information, my reputation. It should not go out. So that is right to be forgotten. So obviously, this right to be forgotten is an inherent part of right to privacy. Right? D is the correct answer. What about the other options? Under right to be forgotten, you also have the right to take down a court order. If that court order, because court order can be in a situation where it affects the reputation of an individual. Okay. So individuals have the right to take down a court order. So option A is wrong. Option B, IT Act does not include right to be forgotten. Right to be forgotten is in the protection of private data protection bill. Data protection bill has the right to be forgotten, but it is still a bill. It has not been implemented yet. Next, statutory right under GDPR is in EU, not in the US. It's in Europe. Fine. So answer is D. Let's move to the next question. So answer for this is C. C for Chennai, 1 and 3 only. Now, right to protest. It's a constitutional right under Article 19. How? Because right to protest is covered basically under what? Right to freedom of speech, right to freedom of assembly, right? Freedom of assembly also we saw that individuals can occupy public land to protest, right? So it's a constitutional right under Article 19. What are the restrictions under freedom of speech or freedom of movement, freedom of assembly, right? There are 8 restrictions. So it is not only public order and security of state. You also have sovereignty of India, friendly relations with other states, contempt of court. So 2 is wrong. Option 2 is wrong. And it cannot be a ground for occupying public spaces and public ways for an indefinite time. This Supreme Court said in current affairs as well. In the Shaheen Bagh case, Delhi, anti-NRC protests. In that, you said that yes, you have access to public spaces under Article 19, but you cannot occupy that space for an indefinite time. There needs to be some outer limit. So 3 is also correct. So answer is C. Next question is related to what I just explained. So I'm hoping you will get it right. So this question, I think a lot of you got a bit confused because not enough right answers. Answer for this is C. C for Chennai. Now, how to approach this question, right? You read all the statements. Third statement needs to immediately strike you as wrong because I said that it is not exclusive. Even High Court under Article 226 has jurisdiction for enforcement of fundamental rights. So third statement is wrong, right? So after third statement is wrong, answers between A and C. So you need to check second statement. So you need to check second statement. Is it right or wrong? Second statement is right. In fact, this is one of the powers that only Parliament has. Parliament can prescribe any other court meaning excluding high courts. Parliament has the right to prescribe writ jurisdiction on other courts. In fact, this is mentioned under Article. This is implied under Article 35, and it is mentioned under Article 32 itself. Under Article 32 itself, the second statement is mentioned. So answer is 1 and 2. Next is the last question for today because it's a detailed explanation. Either you know this or you don't. If you don't know this, I'll tell you about all the 4 remaining judgments because they're important. And I'll do this quickly because I need to go. I need to have some other work. So try and attempt this quickly. All 4 cases are quite important. I'll give 10-20 seconds more. Okay, good. Let's move to the explanation. Most of you have gotten it right, which is a good thing because it's a very famous judgment. Answer for this is the Lily Thomas case. B for Bombay. B for Bombay, Lily Thomas case. Let's run through what each of the cases says. First is Aruna Shanbag case. Aruna Shanbag case is related to passive euthanasia. Passive euthanasia అంటే ఏంటి? ఇప్పుడు కోమాలో ఉన్నోళ్ళు సపోజింగ్ కోమాలో ఉన్నారు ఇంకా ఎక్కువ హోప్ లేదు మళ్ళీ రెగ్యులర్ లైఫ్ లీడ్ చేయగలుగుతారు కానీ లేకపోతే కోమాలో నుంచి బయటికి వస్తారని ఎక్కువ హోప్ లేనప్పుడు passive euthanasia option is prescribed under Aruna Shanbag case. Aruna Shanbag case లో ఏం చెప్తున్నారంటే if an individual is not capable of sustaining life on their own and is unlikely to come out of coma, then as per their wishes, if the individual themselves or the family itself wishes for the person to be taken off life support, they should be allowed to. This is known as passive euthanasia. That has been allowed in the Aruna Shanbag case. Next is Lily Thomas case. Lily Thomas case says that appeal, the scope for appeal should not be given. If individual is convicted of an offense more than 2 years, immediately they will be disqualified from their electoral position. If they are MLA, then they will no longer be MLA. If they are MP, they will no longer be MP. Lily Thomas case says that the 3-month period for appeal will be removed. Next is Samatha case. Samatha case you must have heard of, Andhra Pradesh law. This is basically related to mining licenses. Mining licenses were removed. And last is Joseph Stein case. Joseph Stein case is also in current affairs. It is about adultery. Adultery, the law used to not be gender neutral. It used to be against women. Joseph Stein case has made it equal, like it has given equal rights to men and women with respect to adultery.